Hi, this is estate planning lawyer Michael Pevney, and in this video we are going to talk about what happens when you die without an estate plan. But before that, if you have any questions about this or anything else related to estate planning or want more information, please subscribe to this channel, hit the thumbs up button, and leave a question in the comments section. I'm pretty good about getting back to comments. So, what happens if you die without an estate plan? And when I'm talking about an estate plan, I'm mostly talking about a will or a trust. A complete estate plan includes other documents like powers of attorney, Advance Healthcare Directives, nominating a guardian for your little kids if you don't have one. But I'm mainly talking about a will or a trust. Now, I practice law in California, and I create estate plans for families in California. So what I'm going to talk about is what happens in the state of California if you die without an estate plan. Your mileage may vary based on whatever state you're in, but a lot of things will be very similar depending on what state you are in. So the first thing that happens when you die without any estate plan at all is your estate, meaning all of your stuff, will have to go through probate. Probate is the government and state-controlled asset distribution program that is controlled by the courts if you die either with a will or with no estate plan at all. So there are a series of court hearings. A judge will appoint a personal representative that's going to be in charge of distributing all of your stuff. Now, who's that stuff going to go to? Because remember, you don't have an estate plan, you don't have a will or a trust or anything saying where you want your stuff to go when you pass away. This is called dying intestate, meaning without a last will and testament. Intestate, kind of a fancy legal word. So we have to look at the laws of your state, and there are intestacy laws in every state. So in California, we're going to have to look at those laws to find out where all your property is going to go. So if you are married and you have kids, some of the stuff is going to go to the spouse, some of the stuff is going to go to the kids, whether that's what you wanted to or not. If you don't have a spouse and you don't have kids, stuff might be going to parents if they're alive. Stuff might be going to siblings if they are alive. If you don't have any living parents or siblings, stuff might be going to nieces and nephews and even cousins. Remember, you have no control over this at all. You know, the big solution to all of this is to create a complete estate plan. And in California, most of my clients, we kind of center that around a trust, specifically a revocable living trust. Now, that's not all that happens in probate, because probate isn't just you go to court, stuff gets distributed and all that. It takes a lot of time. We have to find out who you owed money to, where all your stuff is, and there are court hearings set months and months and months apart from each other. And depending on what county in California you live in, probate can often take 1.5 to 2 years or even more than that. And probate costs a lot of money. So if you die in California and say you own $1 million home, and there are a lot of $1 million homes in California, probate costs a chunk of what your estate is worth. So $1 million home costs about $50,000 just to get it through probate, and there's not a whole lot you can do about that, especially if you didn't have a will or a trust. So stuff is going to get distributed to whoever the state says it goes to, whether you like it or not, and it's going to take a lot of time, and it's going to cost a lot of money. So we don't want to die without any kind of estate plan in place. The second thing that happens if you die without any kind of an estate plan, and this is specifically for people that have kids that are under 18, what happens is a judge will appoint a guardian to care for them without any input from you. Now that might end up going to a close family member or a close friend. maybe it goes to somebody that you didn't want them to go to. So here's like an example. Say you have a sister. The sister lives across the country, but you are very close with your sister, and you would really want your kids to go live with your sister. But say your mother and father-in-law live close by. Now, you might not agree with their parenting philosophy, but perhaps a judge, if these in-laws come forward, a judge might say, well, these seem like the most appropriate people for the kids to go to, so I'm going to appoint the kids as guardian. So the two things that happen if you die without an estate plan is your entire estate will go through probate, which is time-consuming and expensive, and stuff may very well go to people you don't want it to go to. And for young parents, the second thing that will happen is that a judge will appoint a guardian to care for your children without any input from you, whether you want them to go to these people or not. If you have any questions about this or anything related to estate planning, you can set up a time to meet with me for free by going to ocestateplanlawyer.com. Please subscribe to this channel if you find this video interesting and you want more estate planning information. Leave a comment, leave a question in the comment section. I'm usually able to get back to those comments, and I'm sometimes even able to answer those questions in a video form. Thumbs up if you like it. Thanks for watching.